Well, good afternoon, everyone. Thank you so much for being with us today. My name is Kemper Patton. I'm a labor and employment associate here in our Raleigh office. I'm presenting this afternoon with my colleague Tricia Goodson. Tricia is a partner in our Raleigh office here as well. Our webinar this afternoon for you is entitled Home for the Holidays, a guide to navigating remote work arrangements during the holiday season and beyond. And really, the purpose of this webinar is to arm you with a better understanding of just some of the laws and the legal issues that you might want to be aware of. Number one, when you're considering an employee's request to work remotely, but also number two, when you're making arrangements for that for your employees to work remotely. And in addition to that, we're going to try to just provide you with some useful tips that you may be able to apply to your own workplace with regard to remote workplace requests. Um, if you have any questions during this presentation, just feel free to use the chat function and we'll try to get to them. Alternatively, if you would like to wait till the conclusion of the webinar, I think we should have time at that point as well. But of course, if your question concerns something specific about your particular circumstances or your particular business, then we just ask that in that case that you try to reach out to us directly after the webinar with this contact information that we have on this slide here. Now, of course, we have to give our general disclaimer before we get into our presentation. We just have to say, of course, this webinar is purely educational in nature. It's provided just for general information purposes. It's not meant to be construed as legal advice to you. And it's not meant to be used as a substitute for consulting an attorney either. Again, if you have some questions that do concern your particular circumstances, we'd love to hear from you, but we just ask that in that case, you reach out to us after the webinar is over. We'd love to hear from you. So before we really dive into the nitty-gritty of things, and talk about some of the legal issues and the laws that could be implicated with remote work requests and remote work arrangements, I just want to touch briefly on why this topic is so timely and provide a little bit of background information that I think is relevant for us. So why is this topic so timely? Well, that's because over the past few years, we've seen a considerable shift in workforces where more and more employees are requesting remote work arrangements, and more employers are obliging and providing employees with remote work arrangements. Now you might ask, why is that? And I think the obvious elephant in the room in that case is going to be the COVID-19 pandemic, of course. The pandemic was a really big catalyst for the increase in remote work requests. But it's interesting because I think even since the pandemic, kind of came to its conclusion, employees have still continued to seek remote work requests. And I think now it's something that we're seeing more and more is almost something of an employment benefit, right? Applicants are oftentimes making decisions based on whether or not an employer provides the opportunity to work remotely. So when you couple this with just the general improvements to things like video conferencing technology, like as we are on Zoom right now, that make it easier and easier for remote work arrangements, as well as just the increased flexibility on the employer side when it comes to remote work arrangements. When you think about all of these things together, it's really not surprising that there are more and more requests for remote work, even this long after the pandemic, and employers are more and more willing to oblige those requests. But with all this said, of course, there's also another big consideration, especially this time of the year, and that's the holidays, right? It's in our title for today. During the holiday season, employers are naturally going to see an increase in requests to work remotely just because so many people may be traveling or wishing to stay home and spend more time with the family during the holidays. So I think that's also just a part of why this topic is so timely right now. But I mentioned this So I mentioned this because, yeah, it is timely for right now. But with that said, this webinar is not limited to remote work requests during the holiday season, right? We're talking about remote work requests and remote work arrangements, regardless of when they might occur. That's why our title is during the holiday season and beyond, right? So. With that said, as well, we want to talk today about the legal issues and laws that employers need to be cognizant about with regard to remote work requests. But it's important to keep in mind that there's no federal law or North Carolina state law, at least, that directly addresses specifically remote work arrangements and requests, right? And what I mean by that is there's no federal Remote Work Act of 2020. There's no North Carolina Remote Workers Protection Act or something like that that lists out everything that employers need to know and need to do when an employee requests to work remotely, or how to implement an effective remote work policy or something like that. But there are a plethora of employment and labor laws that both at the federal level, in here in the state of North Carolina, and in other states as well, that could be implicated by an employee's request to work remotely, as well as by an employer's arrangements for its employees to work remotely, even if those laws don't necessarily specifically concern uh, remote work in of itself. And on a similar note, it's just important to keep in mind that just because an employee is granted an opportunity to work remotely, it doesn't mean that an employment and labor laws don't apply to them. So it's just important to be cognizant of labor and employment laws and how they might be implicated by remote work requests and arrangements. So, with all this in mind, we're going to discuss today some significant laws, legal issues, things like that, that could be implicated by remote work requests and arrangements. So, the first thing we're going to do, Tricia is going to talk about the importance of knowing which state's laws apply to your employees. After that, Tricia is going to talk about how some disability accommodations and some similar issues might be implicated in the remote work context, particularly when employers are making a request to work remotely. After that, I will discuss the Equal Employment Opportunity Commission's recent anti-harassment guidance that was released earlier this year, and some of the ways that it touches on the virtual workplace, right? Harassment in the virtual workplace. I'll then discuss just some workers' compensation concerns, some occupational safety laws that might be implicated with remote work arrangements. And then from there, Tricia is going to talk about just some wage and hour concerns with remote work arrangements. And from there, I'm going to touch on some labor and union issues as well. And then at the conclusion of each of these topics, we're going to try to discuss just some useful tips for you and habits that you might consider applying to your own workplace that might be helpful for you as well. And in addition to that, I think at the end of this, we're also going to have just a brief section on just some additional general tips for managing performance and well-being from afar that aren't necessarily connected to one particular legal issue or one law or something like that. But with that said, for now, I'll turn it over to Tricia to start our discussion on the consideration of state laws.
Thanks, Kemper. Okay, so the big question is, do you know where your employees are working when they are remote? This was really became a big thing during COVID because we had a lot of clients that found out late in time that maybe employee A, who, yes, they were working remote because of COVID, but hey, we just found out that they actually decided they were going to quarantine in a totally different state, or and go live with family, and the employer didn't even know that their North Carolina employee was now living in California and working in California. So it is a really big question to know where your remote employees are actually performing the work. So why does that matter? Well, generally, if an employee and the employer are located in the same state, then we know that, for example, your North Carolina employer and your employees are either working on site or remote, but in North Carolina, then generally North Carolina law is going to apply. There are obviously federal laws that will apply as well, but that's a pretty easy one. Everybody's in North Carolina. But what happens when, if the employee's primary work location is actually in another state? One of the, and of course, our favorite legal response is, well, it depends, which is, I know, everybody's least favorite response from us. But the jurisdiction of the employer's home office versus the jurisdiction of the primary work location can cause a conflict. So I wanted to get into this a little bit and why it is important. So we found with after COVID and remote work became a much bigger thing, that one of the benefits to employers was it really opened up the pool of applicants, because maybe now you're not bound and beholden just to North Carolina. You can expand and hire somebody from another state, which is all well and good as long as you know where they're actually working. So the applicable law is really important because an employee who lives or works in a different state can unilaterally subject an employer to another state's law. So if you have an employee who is working remote, you're a North Carolina-based company, and you have an employee who lives in Virginia, and they're a remote work employee, that the fact that you have allowed an employee to work in another state can unilaterally subject you to Virginia state laws. So each state has very different laws. Some are very similar, some are different. So for example, Virginia has unique laws regarding access to personnel files. Well, if your personnel handbook was written for all North Carolina employees and it says you can't have access to it, that could be a violation in Virginia. So it's just really important to know where your employees are working and you become familiar with those state laws in the employment context. Another example here that we've listed is South Carolina has unique laws regarding whether employment relationship is at will. So you want to make sure and be cognizant. California could be like a whole day seminar of the different employment laws that are out there. So it's just really, really important that you know where they're working and you know whether or not you have to comply with the state law where the employee is providing the services. So, but that is not always an easy task to know. So that will require looking at the laws and making determinations. Some things that are implicated here would be taxes and payroll. Some states require employers to withhold unemployment and state income taxes in the state where the employer's home office is located. But then there are going to be other states that are going to require employers to withhold unemployment and state income taxes in the state where the employee is located. So an employee, as I said before, can unilaterally subject the employer to different state laws just because they are performing their work in a different state. Some employees may be subject to income tax in two states, where the employer's home office is and where they're providing services. And then keep in mind that it could trickle down, and some municipalities have additional requirements depending on where the employer and the employees are located. So for taxes and payroll, you really do need to know where your employees are performing services, determine the withholding rules for each state and municipality, determine tax withholding obligations, register for payroll taxes in the appropriate states. You may also need to find out, do you need to be a company authorized to conduct business in that state? Again, each state law is going to be different. And we can't tell you in this seminar, oh, yes, you do have to do that, because it is very subjective to the state laws. So just stay informed of where your employees are, inform the employees of additional requirements, stay up to date on the laws. Some other laws to keep in mind is that some states could have a more expansive paid and unpaid leave laws. For example, Colorado residents earn paid sick leave at a rate of 1 hour for every 30 hours worked. So if you have an employee that's working remotely in Colorado, you may be subject to that law for that employee. California residents get to roll over vacation time that's earned. So maybe you have a PTO policy that says use it or lose it by the end of the year and it doesn't roll over. Well, you may have to treat that employee who's working remotely from California differently. Um, so again, as you can see, there are lots of laws that could be implicated by having an employee in a different state. So it's just best practice is to be aware of that and to look at it. Let's see. So I think your best records are best habits are keeping records of where they are working and what you're putting into place, and consider all these state laws. So then moving on to the next area is the accommodations for disabilities and related issues. So working remote as a potential accommodation for someone with a disability is actually not a new thing. It wasn't something that just came to light with COVID. I think it became um, a much more known thing by employees that maybe they could ask for this. But for example, the EEOC has a work at home / telework as a reasonable accommodation assistance document that they drafted all the way back in 2003. So it is not a new thing for the EEOC. I think it's just more prevalent in the workplace now. So things backing up a little bit for accommodations for disability and related issues. We're talking about the Americans with Disabilities Act, where you are prohibited from discriminating against someone based on their disability, and you're required by law to provide reasonable accommodations. Then you have the Pregnant Workers Fairness Act, which has similar requirements if an employee has known limitations related to pregnancy, childbirth, or related medical condition. And then state laws. So in North Carolina, we have the Persons with Disabilities Protection Act. Again, if your employee is remote working in another state, there could be other state laws that are implicated. So how are the laws concerning disabilities and limitations implicated? Well, covered employees are entitled to reasonable accommodation for their disability or limitation. Meaning, if I'm an employee and I qualify as a worker with a disability, and I come to you and I say, I have this disability and I need to work remotely. That is a trigger that I am seeking it as a reasonable accommodation for a disability or a limitation. This would then all of a sudden you need to engage in the interactive process at that point. Similarly, a remote work arrangement will likely be considered a reasonable accommodation if that employee has been allowed to work remotely in the past, or if similarly situated employees have been allowed to work remotely in the past. So the best habits and practices here is going to be to have a policy about remote work, whether it is we don't allow it or we allow it under these circumstances. That's a great starting place. Even if you have this, we don't allow remote work, then you have to remember, but we may have to, if somebody has a disability or under the Pregnant Fairness Protection Act, someone needs it as a reasonable accommodation. So if somebody does say they need it as a reasonable accommodation, even if you as a company just say, we don't allow remote working, you will have to consider it as part of an interactive process. Treat it as you would any other accommodation request and engage in it. It may be that this person, their job does not allow them to work remotely because all of their essential functions of the job require them to be in the office. It would not be a reasonable accommodation to totally reconfigure their job such that they had no essential functions that needed to be performed in the office. So you don't have to necessarily give them remote work, but you need to engage in the interactive process to determine whether or not it is a reasonable accommodation. And just keep in mind, as with any disability request for accommodation, you don't have to provide the actual requested accommodation if there is another accommodation that will serve the same purpose and allow that employee to perform the essential functions of their job. So it may be that employee requests remote work, but that you can come up with, through the interactive process, a different accommodation that allows the employee to do the work, but in the office. So those are some things for you to consider. Keep records of remote work arrangements and the purpose for the arrangements. And the reason for that is because if you've allowed certain people to work remote and they have the same job, and you allowed them just because they had personal circumstances or they were just a great employee and you didn't want to lose them. And so you allowed them to work remotely. And then you have someone that has the same job that comes to you and they want to work remotely, but they say it's for disability reasons. You're going to have a hard time if they have the same job saying, well, it's not a reasonable accommodation for you because you've allowed others to do it. So just keep that in mind, that if you've allowed others to do it for whatever particular reason, it may very well mean that you now are going to have to allow it as a reasonable accommodation for someone with a disability. So keeping records of the remote work arrangements and the purposes for those could help you determine whether or not you need to do it as a reasonable accommodation. Review job descriptions to determine whether the essential functions of the position can be completed remotely. A lot of times clients come to us and they say, oh, they can't do the essential job functions from home. But then we look at the latest, greatest job description and the client says, oh, but this isn't up to date. This doesn't list everything. So it's a great time to go back and review job descriptions and making sure that you've listed all the essential functions of the job and that they're accurate. It's just a good practice to do that, regardless of remote work, but just in general to make sure you have that. So ensuring essential job functions are up to date is critical. Treating remote work requests due to medical condition as an accommodations request and beginning the interactive process, even if you don't otherwise allow it. Past denials as an accommodation due to the belief that essential functions could not be performed remotely. You may need to revisit that if the employee performed satisfactorily while out of the office for COVID, for example. If you allowed all employees to work from home from COVID, you may have to revisit past denials. And let's see. So those are kind of our best practices with the ADA.
All right. We're going to move on now into our next topic, which is just discussing the EEOC's recent anti-harassment guidance that was released earlier this year, and sort of how that touches on issues with employees working remotely. Now, just for a brief bit of background, when we say the EEOC, that's referring to the Equal Employment Opportunity Commission. That's who enforces laws prohibiting unlawful discrimination in the workplace. Things like, as Tricia mentioned, the ADA, the Pregnant Workers Fairness Act, things like the Pregnancy Discrimination Act. Of course, the big one, Title VII of the Civil Rights Act, that protects against discrimination on the basis of um, race, national origin, sex, things like that. The Age Discrimination and Employment Act, of course, which protects against discrimination on the basis of age, and just other anti-discrimination statutes that all really fall under the EEOC's purview. The EEOC has long maintained this position that discrimination can come in different forms and different varieties, right? And harassment on the basis of a protected class, right, on the basis of something like race, or a disability or something like that, is a form of unlawful discrimination. So you might ask then, well, what does the EEOC have to do with remote work arrangements and requests for remote work arrangements? How could anti-discrimination and anti-harassment laws get caught up in an employee performing duties in a remote work function rather, or in a remote work location rather than on site? Well, earlier this year, April 29th, the EEOC published this guidance on workplace harassment. Now, this guidance is not necessarily considered ruling and controlling law, but it is a good indication of how the EEOC interprets the anti-discrimination laws it enforces. With that in mind, though, this guidance was very broad, it was very expansive, and it addressed many aspects of unlawful harassment that it's really worth a webinar in and of itself. But for our purposes, the question is really, well, what does it have to do with remote work requests and remote work arrangements? So part of the EEOC's guidance addressed whether conduct in a work-related context, but outside of the regular workplace, could contribute to unlawful workplace harassment. And the EEOC's guidance said that unlawful harassment can include conduct that occurs in a work-related context, but is outside of the regular workplace. So there's a quote here that we have from the EEOC's guidance. I'm not going to read the whole quote, but I would point you to the point that is emphasized here, where it says that conduct that occurs within the work environment, or conduct occurs within the work environment if it is conveyed using work-related communication systems. Think about video conferencing technologies, social media accounts, intranet and public websites. And then they also say that, as with a physical work environment, conduct within a virtual work environment can contribute to a hostile work environment. And so the essence of this is that harassment can occur in the virtual workspace just as it can in the physical workspace. And this is particularly the case when you have conduct that is occurring through an employer's channels, things like the video conferencing technology, right? Zoom, things like that. And this is significant because this is exactly the exact type of environment that remote work arrangements exist in, right? You have an employee performing work on behalf of an employer, but in something like their home office rather than on site. They're oftentimes using things like employer email systems, Zoom conferencing, and things like that to connect with other employees because they can't do so being on site. And so the point here is that conduct occurring through those channels can contribute to harassment claims, even though the employee is not working in person or on site. Now, the EEOC in its guidance actually gave us some helpful examples of conduct that occurs in a virtual workspace that could contribute to a harassment claim. So think, for example, things like sexist comments made during a video meeting, ageist or ableist comments typed in a group chat. I think those are pretty straightforward. I think we can understand how those are inappropriate, right? Most people can look at that and I think and understand that that's inappropriate. But some of these other examples that are maybe things that may be a little bit less direct, right? So think about maybe racist imagery that is visible in an employee's workspace while the employee participates in a video meeting. So imagine that you have an employee who believes that they're in the comfort of their own home, and one day they turn their camera on for a meeting, and there's something that's racially insensitive in the background of their screen. That could contribute to an unlawful harassment claim, even though it's something that is from the employee's home rather than the employer's on-site premises. Another example, imagine you have an employee who is working in their remote work office, and again, there happens to be a bed in the room, and they turn their camera on, and an employee makes a remark about a bed being in the room. That could also contribute to an unlawful harassment claim. And so while the first two examples here I think are pretty straightforward, I think these next two are really good to show the extent of conduct that could contribute to a harassment claim, even though it may seemingly be outside of the employer's control. And I say seemingly, as I'll get to here in a moment with some of our best habits and practices with regard to virtual conduct. So, as I mentioned, with regard to best tips, habits, practices, whatever you might want to call it, how can employers protect themselves from harassment concerns occurring in the virtual workspace? Well, first, as we say with just about everything throughout this webinar, you got to look at those policies, right? You got to look at your anti-harassment policies, your anti-discrimination policies, your equal employment opportunity policies, things like that. This has been really a huge part of some of our revisions to handbooks in the last 6 to 8 months. So when it comes to these policies, if you've not looked at those really since this guidance was passed or since this guidance was published, um, I think that's something that you might really want to consider to ensure that these policies cover conduct occurring in the virtual workspace, as well as all the other aspects of this anti-harassment guidance. Like I said, it's extremely expansive. Um, and you also, if you have a comprehensive remote work policy, you also might want to give that a review and just make sure that it addresses things like anti-discrimination and anti-harassment that occurs or in the context of the virtual workspace as well. Next, again, like we'll say throughout our webinar and already have, train your managers and train your employees, right, to recognize, report, and address potential forms or potential conduct that could be considered a form of virtual harassment, right? So let take it back to the example I mentioned of from the EEOC's guidance, where an employee has something that is insensitive in the background of their Zoom camera. You want your managers to be able to recognize that and deal with it and also to report it to the right channels, right? So that the employer can conduct an investigation if necessary. And finally, I think this is something that's really useful, not only just for this anti-harassment part of the webinar, but just in general. Train employees to treat their remote work locations as extensions of their office workspace, right? If an employee has a remote office where they perform work on your behalf, the idea is you want them to know that the rules of the workspace and the laws governing the workspace apply to that location, and employees need to be made aware of that, right? Employees oftentimes will treat that home office differently because they're not on site, but they need to be. It's helpful to train employees to understand that they're expected to handle their remote office um, and their own conduct while working in their remote office as if they're in person on the employer's premises. So, with all of that said, now we're going to move into the next topic that we have, which is workers' compensation laws and occupational safety laws. Um, as a brief reminder, as Tricia has already mentioned, this is workers' compensation laws differ from state to state, right? It's essential to know what state's workers' compensation laws are going to apply to each of your employees. In the With workers' compensation in particular, most every state's going to require employers to offer workers' compensation insurance to employees in some capacity, but those requirements for employers might differ from state to state with regard to how much workers' compensation must be provided or the requirements of that workers' compensation insurance. And an excellent example of this is with agriculture employees. A lot of states have sort of unique or differing requirements for agriculture employees in particular. North Carolina employers, generally speaking, do not need to offer agriculture employees workers' compensation insurance. Now, this is a general statement. There are certainly exceptions to that, but for the purposes just of this example, like I said, generally, North Carolina employers don't have to provide certain agriculture employees with workers' compensation insurance. Now, our neighbors in Virginia, on the other hand, it's pretty much the exact opposite. Virginia employers generally do have to provide workers' compensation insurance to agriculture employees. Again, that's subject to certain exceptions that are not relevant for the purposes of this webinar. But the purpose, and I think what you can take away from that, is that if you have employees working remotely, you need to know where their remote location is. So, as Tricia has already said, you can consider whether they might be entitled to additional workers' compensation insurance that you may not be providing with your workers' compensation coverage. If you're a North Carolina employer and an employee is working in a different state, say Virginia, you might want to consider, well, are there requirements for workers' compensation in that state that I need to be cognizant of that may not be covered by our workers' compensation policy? So I wanted to mention that just as a reminder of what Tricia has already said, which is the importance of just knowing the state law that might apply to your employees, because it really does have an impact on just about every aspect of employment law that applies to your employees. Now, moving beyond that and getting into a more specific discussion about workers' compensation laws that could be implicated in a remote work arrangement. Because I'm sure there's probably some of you that might wonder, well, why might an employee need a workers' compensation claim when working remotely, right? How might that apply to a remote work setting? Well, that's because injuries occurring in a remote work setting, such as an employee's home office, can be covered by workers' compensation laws if they meet the legal requirements of any other workplace injury that is covered by workers' compensation laws, right? There's no difference. Workers' compensation laws don't they don't distinguish between on-site necessarily and remote injuries, right? As long as they meet the same requirements. Now, like I mentioned earlier, those requirements will depend on the state, but generally, and this is the law for the most part in North Carolina as well, injuries can be covered by workers' compensation laws if they are the result of an accident arising out of and in the course of employment. So you may ask, well, how does an injury like that occur while an employee is working remotely? Well, and there are really two sorts of, I guess you could say, categories of injuries that oftentimes arise. One is just an unfortunate slip and fall incident, right? Imagine an employee is getting up from their office chair in their home office. They're going to grab something that they had printed out, and they trip and they hurt themselves. Right? There's a strong argument there that workers' compensation would cover that. Now, it's very fact dependent. Compare that to an incident where an employee is having their morning coffee, they haven't opened their laptop yet, and while they're walking around in the morning, they trip and fall and they suffer an injury or something like that. That's a lot less likely to be covered by workers' compensation laws. Um, so it's very fact dependent, but that is really one category of an injury in a remote setting that could implicate workers' compensation. The other example of some common remote work injuries are those that would arise out of the workspace having poor ergonomics, right? So think about the employee who is sitting and typing at a computer all day and they have a terrible office chair um, or they have an old keyboard that doesn't have a lot of support, right? Maybe they get a back issue. Maybe they develop carpal tunnel syndrome, for example. These might also be covered by workers' compensation laws, like I said, if they are injuries arising out of and in the course of employment. So, with all that said, it's just important to keep in mind that because an employee has a remote work arrangement, that doesn't mean that they're exempt from workers' comp laws. And we actually do see examples of that happening with remote work arrangements. Now, I do want to briefly touch on occupational safety laws to be aware of. So, just a brief bit of background. There's OSHA, right? The Occupational Safety and Health Act. There's North Carolina has something similar as well. There's other state occupational safety laws. And for the most part, these laws require employers to provide employees with a workplace that is free from safety and health hazards, right? Now, the thing that comes to mind for more traditional workspaces in this regard is going to be like having railings on high ledges, right? But at least OSHA, or excuse me, the Occupational Safety and Health Administration, which enforces OSHA, has said that in its view, OSHA applies to both the in-person workspace as well as the home workspace, right? So these obligations would apply not only to an employer's on-site traditional workspace, but in the remote workspace as well. Now, I say that all that with a brief caveat, which is that OSHA's own policy, the Occupational Safety and Health Administration's own policy regarding remote work arrangements, is that it's not going to go knocking on people's doors and demanding to see people's remote work setups, right? That's not going to happen. At least that's what they've said they're not going to do. And they're not going to hold employers liable for an employee's home work location. But nevertheless, I think it's a good habit to work with employees to ensure that they have a remote work office that is safe and free from potential safety concerns, given that it is consistent with obligations under occupational safety laws. So, with all of that said, a few tips with regard to workers' compensation issues and occupational safety laws. Number one, take steps to ensure your employees' remote working conditions are free from just safety and health hazards. You know, make sure that you might consider offering a more ergonomic workstation or something like that. Um, that's a useful tip that might be helpful for you. And as we've already mentioned, train your managers, right? They need to be able to recognize that there's safety and health hazards even in a remote workspace. And that goes hand in hand with the next one, right? Encourage employees to report potential safety and health issues involved in their remote work arrangements. And last, as I mentioned earlier, just review those state laws that your employees might be located in and determine if necessary um, whether or not you need to reconsider your workers' compensation coverage given the state laws that your employee might be working in. And with that in mind, I believe we're going to Tricia for some wage and hour concerns. Tricia, I think you're on mute.
Thank you. That certainly helps to take myself off mute. All right, so wage and hour concerns. Federal law is going to be federal law, wherever your employees are working in the United States. So you'll have to continue to comply with um, Fair Labor Standards Act. North Carolina has its own Wage and Hour Act that you have to comply with for employees in North Carolina. And then, of course, as I'm going to sound a little bit like a broken record, other state laws depending on where your employees are located. So keep in mind that covered employers have to comply with the obligations under these laws, regardless of whether employees are remote or on site. So you have to comply with the overtime laws and minimum wage, etc. All of that still applies. So um, compliance with wage and hour laws can be challenging when the employees are working remotely. So particularly for non-exempt employees, employees who are entitled to overtime if they work in excess of 40 hours in a work week. So really important to have employees deemed non-exempt or exempt correctly. So I'm just going to put a little plug in that. That's important regardless of whether or not you have any remote workers. Making sure that your employees are correctly classified as exempt or non-exempt is very important. Um, so for employees that are deemed non-exempt, they're going to be compensated based on their time they spend working. So employees have to be compensated for all time worked, both authorized and unauthorized. Meaning if you have an employee that, and this goes for on-site or remote, if you have an employee that works overtime and they weren't authorized, you can discipline that employee for working unauthorized overtime, but you still have to pay them for the time they spent working. Um, so you want to also know that break time can be dictated differently by state law, and you want to ensure that break times are being handled appropriately. Some states may have a higher minimum wage requirement. Some states may require reimbursement for home office expenses. So internet, cell phone, printers, Zoom, things like that. So again, you'll want to check the state laws to see if there's any requirement for reimbursement. Um, in checking with the remote work states, such as if you have employees in California or New York, etc., it may vary how overtime is paid and when it's required to be paid. I believe California may even look at it daily versus weekly. So it's really important to make sure you're complying with the state laws as well. And for the meals and rest breaks, again, some states may require longer breaks. Some may not require any breaks, but you just want to make sure that you know what that law is and that you provide the breaks if they are required. Pay transparency laws vary from state to state as well. Some states require an employer to disclose the salary range or prohibit employer from asking about salary history. So again, you just need to look at where your applicants are living and working remotely. So some best practices here would be to have your employees accurately record hours. It's critical, especially when working remote, but also when working in the office. You want to have clear policies. So you want to have strong policy that prohibits off the clock work that prohibits underreporting work hours and that prohibits unauthorized overtime. And the reason why you want to have a strong policy that even prohibits underreporting hours is you want your employees to understand that you intend to pay them for all time worked. And so you want all time worked to be recorded, but that you are prohibiting anybody from working overtime when they haven't been authorized to work overtime. Train your managers on this policy. You do not want a manager saying, well, you got to get this done and we don't allow overtime, so you figure it out. If you have to work off the clock, work off the clock. You want to train your managers that they understand that underreporting work hours is a prohibition of your policy as well, because you don't want managers encouraging employees to not record their time. So you also want to just something to consider for remote working is consider schedules when employees are in different time zones. So making sure that employees understand when they have to record work time and how they do that is critical to making sure you're complying with the laws, and knowing what the various state laws are is also critical. Let's see. Kemper? Yeah, there we go.
All right, I'm going to briefly just touch on some union and labor issues, and then I think Tricia's going to finish it out with our final category. So with that said, a brief bit of background. Um, when I say union and labor issues, I'm primarily talking about the National Labor Relations Act, right? The NLRA. This is the federal law that governs employees' rights to seek and to improve the terms and conditions of their employment. And this is generally going to be relevant in two contexts. One, where employees are seeking to unionize, in turn, that would include engage in collective bargaining with their employer, right? That's the negotiations with their employer, trying to negotiate with the employer to improve the terms and conditions of employment, their compensation, benefits, things like that. Um, and number two, something very similar, but comes up in different contexts a lot, is where employees are just trying to communicate amongst each other with regard to their conditions of their employment. So, how do these relate to remote work arrangements? You might think if it's anything, it's less impactful where employees are working. But that's not necessarily the case. I mentioned that under the NLRA, employees may seek to unionize and engage in collective bargaining with their employer. If so, the employer is generally going to be required to negotiate with employees about various terms and conditions of employment. Again, right, benefits, pay, but lots of other items as well. And one such item could be remote work arrangements. So employees may come to the bargaining table with a unionized employer and say, we're seeking all sorts of concessions, but one of those might be that they want to work remotely at least one day out of the week. So particularly for unionized employers, um, but also just it's useful for all other employers to know as well. Remote work arrangements could become a term of bargaining. I think they are becoming a term of bargaining more and more. Um, as we see more and more requests for remote work arrangements and things like that. Um, Another way that labor issues could be implicated with remote employees are circumstances where, let's say, a remote employees want to communicate with each other about the terms of their employment, right? Maybe not necessarily unionizing issues, but they just want to communicate with each other about the conditions of their employment, which they're allowed to do under the NLRA. So how might this happen, right? Let's say there's a collection of remote employees that want to gather around and discuss their wages with each other, which again, they're allowed to do so under the NLRA. But they're remote employees. So let's say they want to use an employer's Zoom conferencing technology to do so. Can they do that, or can the employer prohibit employees from using its own property for those purposes? And as I unfortunately have to use our favorite answer, it depends, right? It depends on a variety of issues. It's going to depend on, if employees are trying to hold this conference during work hours, if they have other reasonable means of communicating with each other without the video conferencing technology. And as well, if the employer is just outright discriminating against the employees for trying to engage in their protected rights. So these are all factors in that analysis. And as there's an increasing number of employees that we are seeking that we're seeing seek remote work arrangements, I think the prevalence of these issues may increase as well. So just quickly for some habits and practices um, with regard to labor and union issues. If you're a union employer, consider if your collective bargaining agreement addresses remote work. If not, just be vigilant that it's something that could become a potential bargaining term in future negotiations. Number two, we have here briefly just monitor updates with the new administration coming in, with the new presidential administration. Labor laws are just changing so often. It's part of why we're not spending too much time talking about it today, is just because they are always changing, particularly from administration to administration. So it's just a good idea to keep an eye out on that. Um, Avoid discriminatory practices when offering the use of virtual technology in a non-business purpose. Um, so I mentioned the example where remote employees might want to use an employer's Zoom conference technology to discuss the conditions of their employment. Well, what if the employer, say, allows employees to discuss all sorts of other non-work related things through their Zoom technology? Say the employer knows and allows its employees to use its Zoom conference technology to do things like hosting a virtual book club or something like that. If the employer knows about this and allows this, but it doesn't allow the same employees to use that technology for uh, things like discussing their wages. There could be a an issue of discrimination there. So that's something to be aware of. Just avoid discriminatory practices with regard to the use of your property. And finally, just like with anything else, review and revise those policies concerning the use of your virtual technology for business and non-business purposes. I say review and revise if necessary, of course, just to be consistent with labor laws, both federal and state. And with that in mind, I believe Tricia has some concluding tips on managing performance and well-being.
Yes. So we are, this will round up our presentation. So if you do have any questions, feel free to put them in the chat and we will try to address them at the end. But so concluding, first, you want to decide whether or not you're going to offer work remote arrangements in the first place. You don't really need to wait for an employee to ask. You may want to go ahead and proactively decide, is this something we want to do as a company? If yes, then our next tip is going to be have policies in place so that you don't need to wait for an employee to ask. But if you decide we are not going to do remote work, you have to keep in mind what we talked about for the ADA. And you may still need to, as a reasonable accommodation, provide remote work for an employee that can perform the essential functions of the job remotely. Of course, you wouldn't have to do it if they can't perform their essential functions of the job remotely, but you would need to engage in that interactive process to make that determination. If you are allowing remote work, I would check in with remote employees on a regular basis. Um, ensure the continued compliance with your policies, make sure this is working, and that you feel like everything's being addressed. Next, I would craft a comprehensive remote work policy, and some things that it should address would be compliance with applicable state and federal laws. Determine who should be allowed, like what are the eligibility requirements if you're going to allow remote work. What work can be done remotely? What criteria should the employees have to meet? Should it be any criteria you're going to do should be objective. There should be legitimate business reasons and consistently applied to avoid discrimination concerns. So if let's say you have it as a benefit and that employees that have worked for you for 2 years can work remotely 2 days a week. Yeah, you can come up with your policy. Of course, my caveat is anybody that needs a reasonable accommodation that doesn't meet the eligibility, you may have to waive the eligibility. But it's just a good practice to be consistent when you're deciding who can work remotely and who cannot work remotely, because you don't want it to lead to discrimination complaints. Certain positions may be better suited. So ensure job descriptions are up to date and identify the essential functions so that if you do have somebody that requests to work remotely, whether it's personal reasons or as an accommodation, you can say whether or not they can provide the essential functions of the job remotely or not. You would want to address maybe processes for requesting and authorizing and terminating work from home arrangements. And I would recommend that notices and rationale should be documented in writing. Some other things you're going to want to look at is confidentiality requirements. So you want to protect your company's confidential information. That may be trade secrets, it may be customer and client data, it could be employee medical information, or maybe you're a medical provider and you have patient medical information. So before you allow a remote work scenario, you're going to want to make sure you are protecting your company's confidential information. I would work with IT professionals and understand the common and latest methods of attacks so that you can prevent any avoidable attacks on your system. Train employees on how to avoid attacks, but also have a process for returning company property when employment ends, including and especially your confidential information. Um, and then you're going to want to make sure that you're complying with any laws regarding confidential information. Think about the locations approved for remote work. Do you want your employees that are doing remote work to be able to work on a public Wi-Fi at the Starbucks? Or do you want them to be at their home office location where you have a more secured internet connection? So those would be things that you would want to think through as the locations approved for remote work. Whether remote work is a benefit or an entitlement, meaning you want to make it clear if this is a benefit you're allowing somebody, that you could take it back, that you don't always have to allow it, again, with the exclusion of reasonable accommodations. And then you want to look at whether you offer technological support for remote work. You might even want to think about what happens when the employee loses power or their internet coverage because of weather. What are you going to do on days like that? So I think that you just want to think through and craft a remote work policy so that you have already thought through it and you're not reacting to a situation, but instead you can just apply your policy. And then train your employees and the managers on the policy. Um, those are some good tips. So I think that is the conclusion of our presentation today. We appreciate you attending. And like Kemper said at the beginning, if you have any questions you want to ask us offline, please just reach out to us and we'll be glad to answer any questions you may have.